Hi, this is Rahul Reddy. Along with me is EB Neumann. We are here to present the immigration options for the people who are in the United States. Here is my business partner, EB Neumann.
Thanks for joining us today. We're coming to you live from Houston, Texas. We're here to answer your questions on the employment-based immigration topics, as well as discuss what the latest trends are. If you have a question, feel free to ask either on Facebook or on YouTube. If for some reason we're not able to get to your question today, you can always go to one of our daily conference calls. You can get those by going to rnlawgroup.com. There you'll find the login information and the times for that. And if you'd like more detailed information on your specific situation, you can always set up a consultation by going to rnlawgroup.com as well. So one of the topics we wanted to discuss today is EB5. With EB2 being backlogged, EB3 being backlogged, now EB1 is backlogged. What options do people have if they have money to invest for EB5? Is it a good option? How long does it take? Kind of, if you can walk us through the mechanics of what happens in an EB5 petition.
Let me explain some of the basics for the EB5. EB5 is an investor visa which requires the foreigners to invest a certain amount of money. There are two categories on the investor visa. One is the investor through a USCIS approved agencies where your investment can be $500,000 instead of the statutory limit of $1 million. There is a different set of rules for the targeted these targeted USCIS approved agencies as compared to if you were to invest yourself. EB5 normally requires $1 million investment, and the business must be a new business. It must create 10 new jobs. The business must be new. You cannot buy an existing franchise. It has to be new business. That's the rules for the EB5. The $1 million should be the money that you invest into the business. If it is taken by a bank, you are not risking. If you loan by a bank, you're not risking the $1 million. Hence, you're not eligible for it. However, there are exemptions available that if the business is in a small town where the population is less than 20,000, it could be instead of $1 million, it could be $500,000 investment. Remember, the rules are still the same. It must be a new business. It must still create 10 new employment opportunities. Now, there are things that are regionally approved agencies by the USCIS. Now, they may not be in a small towns, but they may be eligible under limited circumstances where your investment can be $500,000 and you can still qualify for under EB5 options. At this point of time, the EB5, there are two different categories. One is a regional center, one is a non-regional centers. The non-regional centers is current for most of the nations except China and for Vietnam. For the regional centers though, it's very unprecedented. We're going to discuss a little bit more detail later on that. Right now it's unavailable, but until about 2 to 3 months ago and all the way before, from past 10 years in the regional centers, the priority date used to be current for almost all nationals except for Chinese nationals. But Emily, is it like the EB5 option, like I can just put a $500,000, transfer my bank account to a regional center, and then I get a green card? Well, this is blue, but can I get a green card? Go pay the $500,000 and get a green card.
Well, it's definitely not that quick. There's several steps involved in the process, and the green card that you get initially is a temporary green card.
I want to interrupt one thing, Emily. I'm going to act as a client right now, just to extract questions from you. I've been hearing a lot of the online information, a lot of presentations wherever I go. Even I personally was being handed over cards. We invest with us for $500,000. You are going to get an employment authorization within 3 months once you invest with us. Is that possible?
No, it's really not possible. Once the investment is there, the first step is filing the I-526 application, and that by itself is taking, what, 2 years to process?
According to the government website, it's taking 24 months to process it, Emily.
And during that time, there's no EAD. You don't get a work permit during that. It's only when that's approved, when you can file the 485, then you would get the EAD, possibly within 3 months. So it is not a fast process. 2 years to get to the filing of the 485, then you've got to wait during the 485 processing times, go through the interview and all of that, just like all the other employment-based categories. So that's probably another year waiting until you get the green card. And when you do finally get it, it's only valid for 2 years.
What? Am I paying $500,000 for a 2-year green card?
Right, yeah. Now,
Okay.
after the 2 years, you have to file another application to remove the conditional portion of the green card. And how long are those taking these days?
It's taking, according to the government's website, it's taking out 27 months to 36 months. That's what the USCIS website is saying. If I were to believe that normally US website is way off by about 5 to 6 months in these cases, Emily.
Yeah, so really you're looking at from the time you're making the investment and filing the I-526 to the time you actually get a permanent green card, it could be anywhere from 6 to 8 years, not just 3 months. And that's assuming the priority date is current, which it's not right now.
Right
it's
now, it's not.
unavailable. And because even if they were available, more and more people are turning to the EB-5, which means it is likely to eventually become like EB1, to where it's backlogged as well.
Let's dispel the fears, some of the things. So there is a probability that you can invest with $500,000 in the targeted, in the regionally accredited areas. But what you're telling is that the employment authorization will not be given within, it is not possible within 3 months. It may be possible if you get the approval in the I-526, somewhere between 2 years and 4 months to about 3-year period of time, you're going to get an employment authorization because you will file the adjustment of status. Now, adjustment of status is going to take its own sweet time, and then 2-year waiting. The whole process is 6 to 8 years. So, but to get an EAD, if the dates are current, and which you are telling the dates are not current for the regionally accredited agencies, if the dates are not current, if the dates are current, then it's going to be 24 months to 28 months. But if the dates are not current, then you have to wait just like the way. What
yeah,
if,
and the dates are likely to just getting more and more retrogressed. If you just look at the number of petitions that are being filed, I mean, we pulled out the information from the USCIS website on the number of I-526 applications filed each year from 2008 through 2017 over this 10-year period. It increased by 10 times. So 10 years ago, about 1,200 I-526 applications were filed that year. And last year, 2017, 12,000 applications were filed. So certainly this is becoming a more popular category, which means that it's more likely that it'll be retrogressed just like the other categories.
can I move from my EB2 priority date to EB5, Emily?
Oh, I don't know.
No. You cannot move from EB2 to EB5. You can move to EB2 to EB1, but you cannot move to EB2 or EB3 or EB1 to EB5 because this is an employment base, that's an investment base. You cannot move from those categories. Now, having been told that at the same time, though the number of applications in this 2017 are saying it's 12,000, we still don't have a data for 2018. We still don't have a data for 2019. And for you guys to let you know that 2020 already started. 2020 already started. 2020 starts 2019 already started, sorry. So we still don't have a data for 2018 and 2019. We are expecting that based on the delay in the applications are going to be very humongous. Also, we noticed that in a lot of these ethnic groups, when I go, Emily, there are so many new EB5 regionally accredited centers that are opened up. So I'm expecting the applicants to grow up very significant number compared to what they are and I am also expecting a backlog for Indian nationals. At this point of time, we do only have for Chinese nationals and Vietnamese nationals. I'm expecting a backlog for Indian nationals pretty soon. Anything else on the EB5? Also, please, when you are investing in these agencies, please check very carefully. A lot of clients come to us, can you verify the information? Can you do all those things? We are not investment advisors. Personally myself, I'm a very poor investor, so don't ask me investment advices though. I will leave to Emily for a jurisdiction of what she's going to say about our investment advice. But we are not investor advisors. You are entrepreneurs. You need to take care of those things very carefully. We have noticed that some of these agencies have cheated people, and people have lost the money and not get the green card. And that's what surprises to us, is that if you lose the money, at least if you get the green card, I'll be happy. If you lose the money, if you don't get the green card, that's very saddening, and we see them, a lot of those people, very frequently.
Yeah, you can just tell how often these don't work out based on the numbers from USCIS. So as we mentioned, it's kind of a multi-step process, and the first step is getting the initial 2-year green card, and then after 2 years you have to file another application to remove those conditions. So just to give you an idea, if we're looking at, say, in 2014, for example, this I-526, the very first step to get the initial 2-year green card, about 10,000 petitions were filed in 2014. So that tells you if they finally get the green card, the 2-year green card, in probably 2017 is about the time that they'll be ready to file to have those conditions removed. So again, in 2014, 10,000 applications filed, 5,000 of those were approved, but then 3 years later, when it's time to remove the conditions, only 2,600 applications were filed. What happened to all of those other people that filed? Either some of them, the I-526 was denied, but even those that were approved, so going back 2014, 5,000 I-526s were approved in 2014. In 2017, we should expect to see about 5,000 applications to remove the conditions, the I-829 application, but we only saw 2,500 applications filed, which means, did the investment fall through? Is it no longer there and you're not eligible to remove the conditions? So there seems to be a lot of risk in this category. Not to say it's impossible, but it doesn't work out for everyone. So you should know that going in, that you might ultimately not get the permanent green card just based on the numbers.
Turning to the EB1 option, Emily, as the people are wanting to get the green card faster, naturally, because coming from the countries where numbers are backlogged, is an option for EB1 for people. And a couple of questions that I get, I'm going to ask you and make sure that I get the answers from you, Emily. Is that if I am at a managerial level and I already have an EB2 approval and I manage 15 people, can I get a EB1 approval? I'm on H1B here.
Well, if you're here, no. I mean, in order to qualify for the EB1C, you have to work outside the U.S. for 1 year in only a manager or executive capacity. So if you've been here in the U.S. on an H1B, even if it's in a manager role, you still don't meet the qualifying employment outside the U.S. And you have to have a relationship between your company in the U.S. and a company overseas as well. So just being a manager or executive in the U.S. does not automatically qualify you. So then the next question is, okay, well, my company does have a foreign branch. What if they send me overseas for a year and I work as a manager or executive? Can I come back and file in the EB1 category? And it's possible to do, but there are some risks involved. I mean, so you're already here, your family's already here, you're settled, you may have kids here in school, waiting, of course, for your priority date to become current, and now you're going to take a big risk to go back outside the U.S. for an entire year And then what happens at the end of that year? What if the L1 to bring you back gets denied? Or what if you come back and then the I-140 gets denied because the position wasn't manager enough or it wasn't executive enough? So it is, it's not super easy just because the company says the position is called a manager or an executive. USCIS doesn't always buy that. It's really based on the specific job duties, and a lot of documentation has to be submitted to support that. So it could work theoretically, but practically I don't know if you think that's a good idea.
To leave an existing job and then move to any country and stay, the whole family, and then stay there for 1 year, and then expecting that they're going to come back and get the EB1 approval, I think so that's a very heavy risk that they're taking. I would recommend that they get a proper advice from the lawyer before they analyze all these things if they wanted it. If they really want to go out of the country and then stay for a while outside the country and then want to try the EB1 option, that looks to be very viable. But if that's not what it is and you're just going to upgrade yourself from EB2 to EB1, I'm not sure I would do it, because the amount of risk involved, and based on what you're saying and what my observation, Emily, is the EB1 is very risky. The percentage of approvals is very low for EB1C, so I won't do that. What about this this extraordinary ability, Emily? Have you thought about it? What if I have, I'm special in my office, can I get a extraordinary ability, the EB1A the one option, there's EB1-1, EB1-2, which is outstanding professor, EB1C, which is multinational manager. Is that something that you want to consider?
Yeah, I think it really depends on the specifics of the situation and the field, and you really have to be able to designate what field of study or what field you're going to be working in and make it a very narrow field, and then within that field, how can you show that you're the cream of the crop? So they're going to be looking at what salaries you've been offered in the past. Have you been working in the past for other high-level organizations or well-known organizations with a distinguished reputation? What kind of groups have you been involved in? Do you have membership in an organization that has high standards for becoming a member? So there are, it's not super easy to get into that category either. It really does require extraordinary level in order to get there. Yeah, not everyone can qualify for it, for sure.
Yeah. Emily, and what about the updates that you have written an article on the H4 EAD litigation and the STEM extension litigation? Can you update the people on what's going on that, Emily?
Yeah, so the H4 EAD litigation, for a long time that was put on hold because the Department of Homeland Security kept telling the court that they're in the process of proposing a new regulation on the H4 EAD, so they wanted the court to hold everything until that could go through, because once we have this new regulation, we might not need a decision in the case anymore. So the court did put that on hold for a long time, and we were expecting to see a proposed regulation by the end of last year, and it never came through. At some point, the other party in the lawsuit, the group of tech workers, are tired of waiting and they want the case to move forward, so they filed a request for the court to remove the case from abeyance, meaning that we want this case to proceed on its merits. And the court agreed, basically because DHS, in their mind, has been dragging their feet on this new regulation. So now everything's back on. Recently, new briefs had to be filed. We're basically at the very beginning of this process. And so we had one side filing their brief, basically arguing that the administration does not have the authority to give employment authorization in this situation, and that it is harming U.S. workers, taking jobs from U.S. workers, and all of those arguments. At the same time, DHS requested to hold the case due to the government shutdown, And as far as I know, a decision hasn't been reached on that yet, but if they don't hold the case due to the shutdown, they're supposed to be submitting their brief within the next 9 days, I believe, by the end of the month. And at the same time, we have the STEM OPT litigation that's been ongoing for years. This litigation is what ultimately led to our 24-month OPT extension rule. It used to be a 17-month extension rule. That was there since 2008. That rule got tossed out during the Obama administration. Now we have the 24-month extension rule plus the training plan I-983 requirement. Now the case is back on because, again, it's very similar to the H-4 EAD litigation. They're arguing that the government does not have authority to just grant people employment authorization without Congress giving that authority. And so the issue then is, okay, well, we've had OPT for so many years. Why are you just now bringing this lawsuit? And they're claiming it's because the 24-month regulation reopened the issue that allows them to now bring this lawsuit again. So that lawsuit is kind of back at the early stages, and it's going to be months before we get an answer on either of them. As far as we know, I believe in the unified agenda, the upcoming agenda of what the Homeland Security is planning to propose over the next year. There are some modifications they were planning on making to F1 and OPT. We don't know what those modifications are. And we don't know how it's going to interplay with this pending lawsuit. On the H-4 EAD side, I think that we still don't have a proposal. With these briefs becoming due soon and with the shutdown going on, maybe we're more likely to see a faster proposal of the H-4 EAD rule. And what is that rule going to be? We don't know, but we're pretty sure they're going to basically get rid of the existing H-4 EAD rule altogether.
And I know that last week we updated that the USCIS is going to come with the new lottery system. And the OMB is very fast that they took to the OMB. Any updates on that, Emily?
No, as of yesterday, it's still waiting for the OMB to review before the final rule can be published. We should get an advanced copy of what the final regulation is a few days before they actually publish it in the Federal Register, but no action yet on that.
Okay. Any questions from Facebook, Emily?
Let's see. I have a question about extending the H-1B for the 7th year extension, just getting the 1-year extension based on the pending PERM application. How does that work? Does it have to be 365 days from the time the H-1B is maxing out? It really depends on how quickly the PERM is processed. So if you get to the point where the PERM has not yet been approved and you are hitting your 6-year limit, it's not possible to get that 7th year extension unless the PERM was actually filed 365 days or more ago. So the PERM has to, if it's still pending and you're reaching your 6-year limit, it has to have been pending for 365 days in order for you to get the 7th year extension. If it is approved and you can get the I-140 approved, then the 365-day rule doesn't matter. The only thing is you have to have the I-140 approved before you hit your 6-year limit.
Amar has this question. How long it's taking for the H-4 EAD? I'm assuming that he meant only H-4 EAD, not the H-4 plus EAD. H-4 by itself is only taking about 90 to 110 days. However, if you club it with H-4 plus EAD, then it's taking approximately about 8 months to about 12 months. If the H-4 plus EAD is being filed along with the H-1B, 98 or 99% of the time, it will be adjudicated at the same time when the H-1B is approved.
All right, Chaitanya is asking about Vermont Service Center processing time. They're processing some of the more recently filed petitions are getting processed faster than ones that were filed before. They're not following first in, first out. We don't know. We don't have any specifics as to why they're doing that. We do see it from time to time where sometimes they'll work on both ends and try to get the ones that were more recently filed taken care of while they work through the backlog of the older petitions. So that seems like what they might be doing. As far as premium processing coming back, we don't have any updates, no rumors about that. All we know is February 19th, we should expect something. We don't know if they're going to bring it back completely or if they're only going to bring it back for certain types of petitions. I would say based on what they did in the last time around, that probably only certain types of petitions will be allowed to be upgraded first, and when they work through that high volume of filing, then they'll open it up to others. But we don't know if that will happen in February or not.
Dr. Karnatak has this question with regards to the EB5 from YouTube. His question is, what kind of businesses are eligible for EB5? There is no rule as certain which kind of businesses you have to open. USCIS, immigration, is open to whatever kind of business that you want to do. Or make sure that the following criteria need to be met. It has to be a new business. When you say new business, can you go and buy an existing franchise like a McDonald's restaurant? You open a new company and then can you buy a franchise which is already there, just change the company's name? No. The establishment that you're going to do has to be a new establishment. And there are some exceptions, very rare exceptions available for that, but I'm just telling you the general rule. The second thing is that you must create 10 new employment, not 10 new employment opportunities. So those are the two criteria. No restriction on what kind of business it is.
Going back to our discussion of going outside the U.S., working in a manager or executive capacity so that you can come back in and qualify for EB1, the question is, can we port the previous EB2 priority date when you are filing an EB1? And yes, you can do that. So you cannot port a priority date to EB5 from EB2 or EB3, but you can port from EB2 or EB3 to EB1 and keep your old priority date.
Srinivas has this question with regards to the cutoff dates and the dates of filing. He's saying that from February onwards, we cannot file the adjustment of status based on the filing dates. We have to go with the cutoff dates for EB2 and EB3. Srinivas, you are right. From February 1st onwards, we cannot use the filing dates. We have to use the cutoff dates to file. Srinivas has this question from YouTube. He has a question. His I-140 has been approved. I'm assuming that it's been more than 180 days. He now moves to company B, and he's now porting the date from company A to company B. What if company B's I-140 will get denied? Will it have any negative consequences further? No. If your I-140 has been approved and it's more than 180 days, if you move to company B, your company A I-140 will be available for you to use to port the date at any later time. Even though you don't have a company B I-140 approval, you can still extend the H-1B with company B, or you can move to company C with company A's I-140. Even if your company B's I-140 is denied, you can file for your spouse H-4 EAD based on the company A's I-140 approval, even though you're no longer working with company A.
All right, we had a question on EB1. Can a multimedia specialist, such as an animator or motion graphic designer, qualify under EB1? Yes, if you meet those criteria, at least 3 out of the 10, but absolutely in the field of arts, you can use that to qualify for EB1. There's no restriction on which types of jobs can qualify under that.
Does completing a online master's degree, help any way in extending the H-1B? It depends on whether or not it's an accredited university though. If you're already in H-1B and you're pursuing an online degree, there's nothing wrong in online degrees as such, though Emily and I have been quoted many times with regards to the online education system. No, we don't have any objection to online degrees. What we have a problem is when student visa people are studying online degrees. That's where the problem comes. If you're an H-1B, if you're studying an online degree and it's from an accredited university, yes, it will help you in getting the H-1B extension if you complete the degree before you file the extension. But please make sure that the online degree that you are doing is from an accredited university.
All right, question on processing times for H-1B transfers, extensions, amendments, all of those things. They're taking anywhere from, I'd say, 5 to 11 months, depending on the service center, depending on whether there's a request for evidence. Certainly not a fast process right now.
My H-1B stamping is available until 2021. Now I changed the company. Do I need to go for stamping? No, you don't have to go for stamping, but make sure when you come back into United States, you mention to the CBP officer that you are working for a company which is not the one which you have in this passport stamping, but you have an I-797 approval, and then make sure that your I-94 is being issued until the company H-1B approval, not based on the passport. And as soon as you enter, try to retrieve the document. Make sure that you have the I-94 validity until the company that you're working. Because if you stay longer and then you don't check your I-94, sometimes the USCIS does a mistake. Sometimes you might just show the passport and you might give the H-1 approval also. Maybe the CBP officer overlooked and gave the I-94 only until the passport stamping. So you just have to be careful when you're entering, you mention it. Not only that, when you enter, you make sure the I-94 is the valid I-94 that you should be getting in.
Sagar asks, how much time is California Service Center taking when there's an RFE on a CAP subject H-1B petition? They're taking anywhere from 2 weeks to 5 months after you respond to the request for evidence. We still have some from September that we responded to that are still pending, and we try submitting a service request and they say it's still within normal processing time and don't provide us any information. So it's taking a long time right now.
I have some questions on U visas on the YouTube. We have to admit that we are not that good in U visas. Are you?
No.
Immigration, there are many non-immigrant visas: A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U. And each category have different A1, A2, A3. It's very hard for an immigration lawyer to know everything, and we have to admit that no, we are not good in U visas. So, sorry, YouTube customer.
Punkage wants to know if we can control which service center we file our petition to. And unfortunately, the answer is usually no. It's based on the location of the company. So if your company is zoned to the California Service Center and you are filing an amendment or a transfer or an extension with change, it has to be filed in California. You don't have an option of going to Vermont or Nebraska.
One other question from the YouTube, Emily. What are the regional centers that your REDDY NEUMANN PC approves for the EB-5?
Yeah, because, like Rahul said earlier, we're not acting as investment advisors in the EB-5 situation. Our job is to advise on the immigration parts of the process. As far as the investment, we can't say one EB-5 regional center is better than another, or one investment is better than another. That's your job as the investor to do your diligence and figure out whether it's going to be a good investment or not.
Santosh has this question that can we file a transfer application while a notice of intent to revoke is pending? Oh, that's whenever there is a notice of intent to revoke, it definitely is a serious matter. So Santosh, we need to look into very carefully on why the intent to revoke has been issued. We have noticed recently that some of the H-1Bs were being approved without the proper end-client documentation. The USCIS has approved the H-1Bs instead of issuing the RFEs, and then now they're issuing the intent to revoke. And that really creates a lot of problem there, because if the employer withdraws, there are some problem. If employer doesn't withdraw, the previous employer withdraws, there are some problems. Doesn't withdraw, there are some problems. It has to be taken very delicately. You have to get a legal counsel for this. It's just is very serious matter. And if the intent to revoke is been issued for a H-1B, which is cap subject to H-1B, that means that is the first H-1B that you got, you are definitely in a serious issue though, because if it's been revoked, the transfer will be automatically denied. That's the issue that's there that you need to consider.
And even if the revocation happens later, after your transfers are already approved, they can go back and then revoke the transfer as well. So just because you get the approval doesn't mean you're out of the woods yet. Suma has a question about filing a transfer when an extension is pending. And in this situation, the extension was timely filed while it's pending. The I-94 has expired, and now we're looking at filing a transfer. Technically, yes, you can file a transfer in this situation, and you can start to work for the new employer based on the pending transfer. However, because the I-94 has already expired, from the time the I-94 expired, you're no longer in H-1B status, even though you have a pending H-1B extension. You're in what's called a period of authorized stay, which is not the same thing as status. So you're in this period of authorized stay, you file the transfer and continue your period of authorized stay with the new employer, but if that extension gets denied or withdrawn, that is the thing that bridges you from your I-94 expiration, when your status ended, to the filing of the transfer. So if that middle application, the extension, is withdrawn or denied, the bridge collapses and your transfer can still be approved, the petition, but the I-94 will likely be denied. You won't be given an extension of stay. Then you'll have to exit the U.S., apply for a new visa stamp since yours is likely expired, and then come in to get back into H-1B status.
Emily, I want to address the Trump tweet. He wants to make the H-1B job very easy. He wants to move the H-1B guys to the citizenship. And I have a question from the YouTube that the USCIS update of the website, this is, I have to laugh, on the third party, STEM extension people working at the third party site, the update that they can work at third party site as compared to that they cannot work previously. Is that a positive sign? Is that something that came out from the tweet of the Trump administration? The STEM extension, USCIS said in the STEM that you cannot work at third-party site, and they later on retracted, you can work under certain conditions on that.
Yeah, I don't think that's what he was intending by that. I think this administration is not a fan of third-party placement or consulting firms. The timing of the tweet does not make sense with the timing of that action, since that was in January, February, March, and this tweet was just of last year, and this tweet was just recent. It seems the timing makes the most sense when you look at when the H-1B lottery regulation was submitted to the OMB. It was the same day that tweet came out.
That's right. The online lottery system seems to be there.
And he's talking about making it, a more certainty and smoother process. I can't remember what his exact words were, but I just don't see anything else that this administration has done or has talked about that would suggest or give hope to H-1B workers that things are going to get better. I hate to sound so negative.
Except the lottery system proposal, since the administration came in, and that's a proposal, nothing. I mean, we have seen the DACA kids employment authorization been retracted. We have seen the H-4 EADs, which the Trump administration vowed to take it off. A lot of restrictions on the H-1B. If you look into the H-1B denial ratings, they have gone up to about 30% denial rating right now as compared to what it is. I don't think so this administration is trying to do any positive things though.
Karthik has a good question. His wife has a pending H-4 extension that's been going on for 6 months now. Does the 240-day rule apply to her? That's a really good question, and no, it doesn't. So the 240-day rule is only for H-1B extensions with the same employer, and it only is regarding employment authorization. So since H-4 is not employment authorized unless they have the separate EAD, which is a different topic, there is no 240-day restriction for how long someone can stay in H-4 while they're waiting for their extension to be approved. As long as it's pending, if the I-94 is expired, they'll remain in a period of authorized stay until the extension is approved, even beyond 240 days.
Nazneen has this question. The RFP response has been done for internal project, and what are the probabilities of approval? The question is, the internal project is a genuine project. That's the main issue that we have, and we find that there are some companies that are filing H-1Bs that don't have internal project. When our office has been approached for filing an internal project, I mean, it's so easy to file. 100 cases can be filed so easily. We don't need end client letter, vendor letter, nothing. Everything is so easy, same documentation. But we find a lot of inconsistencies in what some of these employers are quoting and what the actual truth is. We normally will look into if there is any money that this company is deriving from that internal project. Now, if somebody tells me that, okay, I'm making an application, this is going to be like a $18 billion WhatsApp application or something like that, and I want to file H-1Bs, are there any employees working for that company? Zip. Are there any revenue coming in? Zip. We normally stay away from that because that's something is a big problem that we noticed. The way you are asking the question, I'm assuming that, yeah, it doesn't look to be good. If the project is good, genuine, the approval ratings for the internal project is definitely higher than the end client because there's a lot of documentation requirement for the end client as compared to the internal project. But the internal project has to be genuine. There must be customers. There must be revenues. I would say that there must be at least 10 US workers already working on that project to consider that as a genuine for REDDY NEUMANN PC. Any correction, Emily?
No, I think that's right. Chaitan has an interesting question. He's been able to get an O1 visa already and is wondering if he should still try for an H-1B in the lottery. He tried for the H-1 before, didn't get it, so now he got the O1 and got it approved.
O1.
Why would you still want to get an H-1B if you've already got the O1? And there are some valid reasons for that. I think probably the number one reason is just it's much easier to change employers on an H-1B versus an O1. It's a much faster process. There's not as much documentation required. You're maybe more limited in the types of employers you can work for if you're on an O1 compared to an H-1B. You raised the question of dual intent. So you're right that the H-1B does allow for dual intent. The O1 is a little bit special. It has what's called quasi-dual intent. And the reason they call it that is for H-1Bs, it's set in the statute regulations that this is a dual intent visa. The O1 does not have that, but the Foreign Affairs Manual specifically says that having an approved I-140 petition should not impact your ability to extend your O1 or get an O1 visa stamp or file an O1, and the same for O3 dependents. So although it's not exactly the same as dual intent for H-1B, it still has the dual intent option. So I wouldn't be as concerned about that.
I have never seen any O1 extension denial in my experience based on the I-140 application. If you are an O1, I definitely, the first thing is that since you already got the O1 visa, you're very close to EB1 extraordinary ability. You may want to, I would try the EB1 option immediately. Yeah, H1, not sure if I do. It's 540, I believe.
Yeah, let me ask, we got one more question here. Very good question now that we have the shutdown going on. So I'm assuming this is someone who's on OPT currently and working for an employer who is not enrolled in E-Verify, and the employer is planning to become an E-Verify employer so that this person can get their STEM extension, because the STEM extension requires that you only work for a company that uses E-Verify. However, during the shutdown, E-Verify is not available. The employer cannot register in the E-Verify system. I have another client just yesterday that we had the same issue come up. So unfortunately, I don't have an answer for you if the shutdown continues and your OPT is expiring. You won't be eligible to extend your OPT without having that E-Verify number. You may have to look for another employer that does use E-Verify, and then later come back to this employer if this is the employer that you really want to stick with. Or if you have enough time on your existing OPT, perhaps your employer can file an H-1B in the lottery to get you the cap gap extension to September 30th, to where you maybe wouldn't need the STEM extension. So that would be another thing to consider. But yeah, while we're on the shutdown, E-Verify is not working, and you cannot enroll a new company if you're not already in it.
I have two burning questions I want to answer on the YouTube, Emily. Karthik has this, he has the EB1 interview and the priority date is not current at the time when he's been interviewed. Do you have to go for the interview again? The most probable answer would be no, you most probably don't have to go for the interview again. There is a slight chance they may recall you for the interview again, but I would say the chance is less than 5% that you will have to go for the interview. Now, this is the closing statement that I want to go with. Abrar has this question. When do you expect premium processing to come back? How much do we have to suffer? We can't go out of the country because of the transfer is pending, or this one is pending. Can we sue the immigration? Is there any solution for this delay? Because now the H-1B, assuming assuming that it's an amendment plus extension, and then if there is an RFE, I mean, God knows, that's like what, 18, 19 months for them to get it? Is there any way to sue them? Are you in the process of helping anybody sue this?
There is a potential for that. It's called a mandamus action. Basically, you're filing a lawsuit that is telling the court to force USCIS to take action on your case due to their unreasonable delay. And we are seeing this happening more and more. There was just a lawsuit filed, I think, last week.
Jonathan Weston.
Yeah. Specifically to force USCIS to act on an H-1B petition that had been pending for a very long time after an appeal had been successful, and they still haven't issued an approval notice. So this is kind of I don't want to say a new concept, because it's worked in other areas of immigration. It's just something that in the employment-based area we haven't needed to use it so much before, because we had premium processing.
When you have a premium processing, pay 1,000.
Yeah.
Pay the money and get it over. Why go to the court? But then it's suspended right now.
Mm-hmm. Yeah. So it is something that you can definitely look into. I don't know how worth it will be if premium is ultimately back in the next month. But if we do continue to see these delays, I think USCIS will be sued more and more.
Thank you, guys. Any other things, Sandra?
I think that's it for today. Thank you for joining us.
Yeah, we couldn't get to all the questions for those people. Please don't remember that we do have a daily conference call. You can log into rnlawgroup.com, and we do have a live daily conference call, half an hour. The timings are that RN Law Group. And for all the current news, you can always subscribe to immigrationgirl.com. And if you want to speak with me, Emily, or any of our talented colleagues, you can always make an appointment